ran over who? That is the big question that should make or break the case against Gwyneth Paltrow for a ski accident that occurred in 2016. But the murky details and conflicting statements are going to make it kind of hard for the jury to pick a side. There's a flurry of conflicting accounts. In some ways, this is a classic he said, she said case. Let's break down what the jury have to go off of so far. Hey, I'm Josh Sanford. I'm America's attorney, and you're here because you want to learn the rules of the game. Well, you found the right place to do so, so lawyer up and let's get started. Now, no one wants to think about getting injured while on vacation, but it does happen. It could happen to you. It's happened to me. And for skiers, there's a good bit of risk involved in hitting the slopes. While the jury has enjoyed the mild 70-degree courtroom, almost all the testimony that they've heard has been focused on the snowy slopes of the Deer Valley Ski Resort in Park City, Utah. So far, there have been two completely different accounts of what happened on February 26, 2016. 2016? Can you imagine? It's been over 7 years since the incident. What's the point of colliding with a movie star if you have to wait so long for your 15 minutes of fame? Paltrow claims that it was the plaintiff, Dr. Terry Sanderson, who hit her from behind. Sanderson claims Paltrow hit him from behind. Now, regardless of who hit who, it was Sanderson who ended up with broken ribs, multiple broken ribs, and a serious concussion, while Paltrow, I was gonna say walked away, but skied away, virtually unharmed. Leading to last week's trial, in which Sanderson demands $300,000, initially $3.1 million, from Paltrow for negligently causing injury, and Paltrow demands $1 plus attorney's fees from Sanderson in a countersuit. Well, we're about 1 week into the trial, and here's what we've learned. It's going to be up to the jury to simply pick a winner. There's no clear version of what happened. Visibility is limited. Multiple witnesses are giving conflicting versions of who ran into who. But before this video is over, you're gonna know who is going to win and why, and it will all make perfect sense. Sort of. The crux of this trial has been trying to figure out who was the uphill skier. This piece of information would change the entire course of the trial. Why is that, you ask? Great question. Because Park City Municipal Code Section 828B states that it is the responsibility of the uphill skier to avoid crashing into anything or anyone below him or her. Meaning, whoever the jury can be convinced was the downhill skier is likely absolved of guilt. Sanderson's attorneys have brought an eyewitness, Craig Ramon, who is a friend of Dr. Terry Sanderson, to testify that Sanderson was, in fact, the downhill skier. Ramon testified that he saw Paltrow run Sanderson over. Well, an eyewitness seems like an airtight angle, right? I mean, this person was on the slopes and saw the entire incident. Well, Paltrow's team has pointed out that when Paltrow's ski instructor, an employee of Deer Valley, said, "Your buddy ran into her," or something along those lines, Ramon didn't deny it. He didn't claim that it was Paltrow who had run into Sanderson. He said nothing. Now, this may or may not be enough to sway the jurors, but it's important to note because it shows how a lawyer's strategy works. The goal is to introduce just enough doubt in a juror's mind that they can't, with any meaningful degree of certainty, rule against Paltrow. Sanderson's team also had a radiologist testify that it wasn't plausible that Sanderson's injuries would have been on that side of his chest if he had been the uphill skier. But Craig Ramon is a friend of the plaintiff, and so there's bias there. And the radiologist is not an accident reconstructionist. Paltrow herself testified on Friday, March 24th. Now, overall, it wasn't remarkable testimony. Paltrow reasserted her claims that she was the downhill skier, and it was Sanderson who hit her from behind. Now, after the collision, Paltrow claimed that she yelled at Sanderson, asking, "What are you doing?" And when he responded that he believed she had hit him, she yelled at him, "You skied directly into my effing back." Now, why would she say that? Why would she yell that? 7 years ago, did she know about Park City Municipal Code Section 828B? That seems unlikely. But maybe she was only acting offended. Hey, When asked about Ramon's testimony that he saw her hit him, she responded that due to the distance, it would have been difficult to tell the skiers apart. She also denied claims that she hit and run Terry, claiming that she stayed around long enough to ensure that everyone was fine and left the Deer Valley ski instructor behind to handle the situation. On top of all that, there's actually a difference in the quality of testimony that's coming from Paltrow and the presumed quality of testimony from Sanderson. If you remember, Sanderson said he got hit on the head. He's got a concussion. Maybe he doesn't remember everything very clearly. I don't know. But Gwyneth Paltrow said that she remembered everything very clearly. She didn't have a head injury. In situations where it's not clear what happened, juries are looking for tells. They're looking for tiny little clues, anything out of the ordinary that helps them decide which side the coin should flip to, because the jury's the one that has to flip it. And here's what we've got. Fact number one, the plaintiff originally sued for $3.1 million. Now, just so we're clear, that's completely insane. That's the most money-grubbing, outlandish number you could ever imagine based on these injuries. And that's not just my opinion. Look what happened when they finally took the case to trial. The plaintiff reduced his demand by 93%. He didn't reduce it by 10%, not by half, but by over 90%. That smells like money grubbing.
Ew, that's nasty.
That's not very likable. The jury, which consists of a bunch of presumably conservative Utes, is not gonna like that. Not at all. Second fact for Paltrow, it ain't about the money. For real. First of all, she's very, very wealthy. Google believes that her net worth is north of $200 million. And so do I. If she wanted to pay like $250,000 to make this case go away, she obviously would have, if she felt guilty about what happened. What's more, she's fully insured. She has what's called an umbrella policy or a general liability policy, and that's gonna cover all of this. So with one word, sidebar, that word is settlement, she could make this case go away, but she wouldn't do it. Why? She doesn't want the hassle of this trial. She doesn't need this in her life. It ain't about the money. Her insurance is paying. Now, the third fact is her counterclaim. Now, filing a counterclaim is not that unusual in negligence cases where key facts about the accident are in dispute. However, her claim was only for $1. $1. Now, that's either kind of clown or she's trying to make a point. I think she's trying to make a point. Those three facts point to the real reason that this case hasn't settled. Really, truly, for her, it is not about the money. Clearly to her, it's about the principle. She was mad when he hit her, and she's still mad. She cussed him out, she says, when he plowed into her, and not settling with him now is her way of cussing him out again. Now, it's almost certainly gonna work because one of the primary drivers, if not the primary driver of the economy in that county of Utah where the trial is happening, is tourism. And it's not tourism like most people know. It's very wealthy people spending thousands of dollars or even tens of thousands of dollars on fancy vacations. The jury doesn't want to do anything to slow that down. Not if they aren't sure that the wealthy celebrity did anything wrong. And Paltrow's lawyers are smart enough and the true facts are murky enough that the jury will award no money to anyone. And that is a win for Gwyneth because she only asked for $1. And so despite all the expert testimony, the eyewitness accounts, the teary-eyed family members recounting angry experiences, Sanderson is still not gonna walk out of that trial victorious or ski out. Hey, you're probably thinking,
Josh, it's barely Tuesday. When you filmed this, there was still 3 days of testimony left.
Now, there are very few things that anyone on the stand, which will primarily be Paltrow's family, could possibly say that will change the bare facts of the case that are already in evidence. Now, stranger things have happened. And if I'm wrong, come back here and just roast me in the comments for my bad call. You can leave it right under your pro se opinion. Have you been watching this trial? What are your thoughts on the testimony that's been given? Who do you think was the downhill skier? Let me know in the comments below. And as always, don't forget to lawyer up and join this community. You gotta learn the rules of the game, and this is the best place to do it. I will see you real soon. Bye.